Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from the Oxford University Press. It's actually come to us from America because it's really a book which is more to do with America rather than the United Kingdom. Just falling over the book itself, there it is. We'll get to you in a minute. It's called The Religion Clauses. It's got a subtitle, The Case for Separating Church and State. It's been written by two people, experts in their field, Erwin Chemerinsky and Howard Gillman. I've given the review title, A Fascinating Question That Still Defies Politics and Jurisprudence in Democracies. Now I say that because my view of this book, and this is the draft version of the book, is based really more on the way in which the US operates within their written constitution and what we might bring from that for the United Kingdom. And that's how I've looked at the book. Here is the actual book itself. It's a paperback, very small paperback. There's the spine. And then you can see it's actually it's a proof edition. There's the back. You probably can't make too much out. Let me just show you the back of it. There are notes at the back. This is actually from OUP in America, as I say. There are a lot of notes at the back which you can see running through, and then you've got the main text itself. It's about 200 pages long. There's the front of the book there. In fact, the main front of the book is that part there. It's a series of books in the Inalienable Rights series under OUP publication. Obviously there are a lot of them. This is it's a short book, and I've found it very interesting. It's easy to read too. The 5 chapters plus a preface. The preface sets out what has been happening recently. I've been very privileged to meet a number of members of the Supreme Court. Clarence Thomas I particularly remember meeting, and obviously we've had the controversy with Brett Kavanaugh, and we're now getting another controversy which I'll be referring to in a moment, with the sad passing of Ruth Bader Ginsburg. But the preface does set the tone quite nicely. We argue for a different vision, the authors say, one that seeks to separate government and religion, both with regard to the Establishment Clause and to the Free Exercise Clause. That really is the basis of where we are. They start on with Chapter 1, which is the competing perspectives of the religion clauses. And they talk specifically about the First Amendment. And obviously they run through from that. They look specifically at the Establishment Clause. Free exercise of religion is looked at, bearing in mind what we have in this country, which is effectively the Human Rights Act, the equality legislation, and a whole range of other pieces of legislation which go with it. Now, I'm going to concentrate really on a comparison for purposes of jurisprudence between what we have in America and what we have here. So what I say is the authors comment, and I'm going to quote some of their comments, that throughout America's history, attitudes concerning the proper relationship between the state and religion have been deeply divided, and they still cause massive friction today. Now, obviously, America is a very vast continent. England, the United Kingdom, is a very small island, but from what we had in this country, we exported our basic common law principles, and of course we are one of the only countries now in the world that doesn't have a written constitution. America does, and of course the question which is raised again with the most recent changes in the composition of the Supreme Court in 2020 has come about because of the sad death of Ruth Bader Ginsburg, and what is happening whilst I record this prior to the presidential election in November of 2020. I don't know the outcome at the moment. Obviously we do have a position where the current president, Trump, is trying to put more relatively right-wing persons into the Supreme Court who have a particular religious point of view. And I think I'm trying to put it in as nice nicest and fairest balanced way, because the issue remains with the First Amendment law itself concerning religion, which is possibly likely to change quite dramatically in the aftermath of this current presidential election, because we don't really know. We will be told in the relatively near future what the Democrats intend to do, but obviously the Republicans are very clear about their stance of changing the balance within the Supreme Court itself. But let me move away from that, because while we're talking about the religion clauses, about separating church and state, we have to bear in mind what has happened within the American Supreme Court itself, because this new book on the religion clauses obviously brings together two of America's leading constitutional scholars. That's Erwin Chemerinsky and Howard Gillman. And now these two gentlemen set out the case by explaining how freedom of religion is enshrined in the First Amendment through two provisions. And whilst this question covers the US, the issues have much wider significance, I believe, for democracies across the world, because we're looking again at effectively a concept of jurisprudence, the theory of law, and where you get the definitions between religion and the state. And of course, in their own words, the writers defend a robust view of both clauses and work from the premise that the Establishment Clause is best understood, in the words of Thomas Jefferson, as creating a wall separating church and state. And I think Jefferson's comments are very important, because this is the basis of the separation of the powers. I say, thus the jurisprudential issue emerges for the 21st century in the form of a constitutional separation of the powers, which is much wider, which is more pronounced, of course, in the US than it is in the UK, because the US has a written constitution with all its pros and its cons. We, of course, don't. The authors then review the major approaches to the meaning of the Constitution's religion clauses. Now, we've had, obviously, in the UK, or in England, we had Henry VIII. We had a very large number of our own issues with Cromwell and so forth. However, what the authors do here is they submit, based on American studies, that the best approaches are for the government to be strictly secular, and for there to be no special exemptions for religious people from neutral and general laws that others must obey. Now, I'm not going to talk about individual religions, because I think that would be very dangerous. It could also cause offence to some people. So I'm taking it on the higher philosophical level, because so far so good for the view which establishes a freedom for all to uphold democratic values, rather than any form of totalitarian approach where one view dominates and subdues all others. Now, as I say, I'm not talking about any specific country or any specific religion, but clearly when you have 70% of the countries in the world that are dictatorships, you can see the problems of abuse taking place. Now, Chemerinsky and Gillman conclude with a view that in an America that is only becoming more divisive with respect to religion, this is not only the fairest approach that they've adopted, but the one most in tune with what the First Amendment actually prescribes. And they go back, of course, to the history of the American Constitution. And such is the practicality of the situation, some centuries, of course, after the original drafting, because the issues still remain the same, and they're not going to go away. We've had the same problem in the United Kingdom. We have legislated, and I've certainly been one of the commentators as a teacher as well as a practitioner, that says you can only legislate so far, you can only take people to court so far, because you've got to have the general agreement by consensus with the public. And I think, generally speaking, we have that, because the issue which is raised is one of extremism, the end of it all. I'm again not going into any specifics, because Henry VIII could have been seen as an extremist. Other people could have been seen as extremists as well. So it's not a question of labelling anything, it's looking at the much wider picture. So the book, The Religion Clauses, is rightly described here as a pithy primer on the meaning of the religion clauses. And it's a short, highly readable paperback in my view, which I found very interesting to read. I now got the uncorrected version, but I didn't spot anything particularly outrageous. I'm sure it's probably the proofreaders will spot something. What the authors have done, though, is they've set out a broad-ranging indictment of the court's misinterpretation of them in recent years. That's their words. We strongly recommend this work because I think it illustrates for students and scholars alike the view of the authors on how a separatist approach is most consistent with the concerns of the founders who drafted the Constitution and with the needs of a religiously pluralistic society in the 21st century. I think it should be required reading for lawyers, philosophers, historians, theologians and politicians. A big thank you to all of them. I'm not coming down on any sides here at all, because what they're doing here is they're opening up the discussion for people who are not going to be prejudging, because this is not about labelling a particular religion as good or bad or anything else. What it's trying to do is to see where there should be the division. It says separating church and state. I view it on the basis that the church and the state are separate. Obviously, we have a different system in the United Kingdom because the Queen is defender of the faith and therefore the head of the Church of England. Now, it's important to bear that in mind because our concepts are different from the American concepts, but there is still one general theme running through, and that's democracy and the freedom to practice a religion. That means tolerance. With that, let's have another look at the book. The date of publication is cited out the 1st of November, and this is an advance review, because I'm reviewing this in October. There's the book again, and then there's the spine, and then there's the back. The cover is different for the printed version. Let's open it in the middle. The Establishment Clause, here we go. We're looking in some detail here at some of the views of some of the members of the judiciary in America, and that's one of the reasons why I thought, from a point of view of jurisprudence, it would be an area that many people might find helpful. You do have some case law, which is mentioned. There isn't, in fact, an index as such, but what you do have at the back of the notes, and so obviously you can find some of the case law references, but they are not cases, obviously, in UK courts. The point I am making, though, is that you can see from the actual pages themselves, there's a lot of detail which tries to set out what is the case for keeping a separation between the church and the state. And of course, I go back to the very basis of the separation of the powers that we have and that the Americans have between the legislature, the executive and the judiciary. We do have that separation of powers, and of course the church, which was very, very powerful in England and in the United Kingdom over many, many centuries. Obviously the power has waned, and it could wane further with the House of Lords changing its structure with the Lords Spiritual, and the whole problem in the future of the very few people who now actually in England go to church. I mean, obviously there are other religions involved, but I believe that the basic case is made out for the separation of the church and the state, but there have to be safeguards. So this is not the end of the debate, it's just the beginning. Thank you to Erwin and Howard and to OUP for what I found a fascinating book. Bye bye.